or good afternoon, or good morning, depending on when you're seeing this show. This is Bob Erwin here with one more episode of Fired Up. We are broadcasting from the law office of Alan Butel in Las Vegas, Nevada. Alan is a frequent guest on the show as a guest attorney, and in fact, he was on last week's show. If you missed it, he's on it. It's up on YouTube. This show is about guns, politics, and self-defense issues. Fired Up is on KSHP Radio 1400 AM. This show is rebroadcast there, 1400 AM radio, on Sunday morning between 9 and 10 a.m. We were having lots of problems with preemption from Dodger baseball, so we found a time frame where the Dodgers aren't playing, and now the radio station is trying to get hockey games, and so we may get moved again. Hopefully not. We'll stay here when you're getting ready for church. Turn on the radio, and you can listen to Fired Up between 9 and 10, 1400 a.m. Anyway, the YouTube version, what we're doing right now, is available 24/7. It's a live broadcast. There's about a 3-second delay at the moment. And we are on YouTube live, actually, as we're broadcasting this. So kind of anything we say goes out over the air. And hopefully we won't say something that offends the YouTube guys and get ourselves cut off. My guest today is local Las Vegas attorney Donald Green. Don, if I could, for new listeners or people not familiar, would you take a few minutes and tell them who you are?
Okay. Well, thanks again, Bob, for having me on. Again, my name is Don Green. I'm a lawyer here in Nevada, and I'm also licensed in California. This is my 34th year of practicing law. The emphasis of our practice is, or are the following subjects: criminal defense, business litigation, and for your listeners and viewing audience, gun cases. And by gun cases, we do a variety of gun cases, from criminal, administrative, FBI appeals, denials of firearms, CCW applications, representing federal firearms licensees, be in ATF audits, you name it, we do something with guns. And they're welcome to call me, 702-409-8239, or they can go to dongreenlaw.com or through your website.
And
the
your
website
for the show, Fired Up with Bob Erwin, has the list of our 4 or 5 guest attorneys that appear here regularly and their contact information. Or you can call or send a note to my email address, bob@firedupmail.com, and I will forward it to Don. If you didn't find that, you can find it during the whole show staring at you on the screen. Unless you're on the radio, of course, then you better listen, because we'll tell you what it is. Mail@firedup. I goofed that up again. Our email address is bob@firedupmail.com. We do answer all questions that come in by text or email. If you have a question or comment, you send it to that address. We will forward it to the appropriate guest or answer the question if it's something directed at me. There are several hundred firearms uses in self-defense every week in the United States. Depending on who's doing the counting, there are a couple hundred a week or 300 or 400 a week. Lots of them aren't reported because there are no gunshots fired. The guy starts to climb in your window, you point the gun at him, and he leaves. And are you going to call the police? Most people don't, because they want to go back to bed. So that isn't reported. But when we do surveys of people, have you had this happen to you? The numbers jump dramatically. So what I do is I sort through the shootings that I've run across during the week. Most of them are good shootings. Some are questionable shootings. Some are foolish shootings. I try to pick incidents that have meaning to our listeners. I usually always take the names out. I give you the location so you're familiar with the laws in that state, so you know what state it happened in, because that matters. What we do on this show is try to give decent advice that will keep you out of a civil lawsuit or keep you out of jail. But understand that what is a good shooting in Nevada is not a good shooting in New York City. What's a good shooting in Alabama isn't a good shooting in Seattle, etc. So if you're involved in an actual shooting, you need to get local counsel. Don does California law and does cases in California all the time. So a lot of our listeners are from California, so you can call Don Green. Otherwise, you need to get a local attorney who's familiar with the nuances of the state law. Anyway, so be that as it may, a reminder that we're using the law office of Alan Butel. He's a criminal and civil defense lawyer here in Las Vegas. He does some general business litigation, and he lets us use his office for broadcasting the show. So we give him a plug here. He has free consultations on cases that come in, as a lot of attorneys do now. You can call him at 702-319-7800. And if you want to see what he looks like, tune in last week's show. It's up on the website.
He's a good-looking guy.
And you will find Alan Butel, ex-Marine, ex-prosecutor,
Highway Patrol,
ex-state trooper in Kansas. So he's really knowledgeable on this stuff, having been a cop and a prosecutor and a defense lawyer. He's pretty good. This first story comes from the Selma Times-Journal and a lot of other media. It was reported on the 1st of June. This is about a week ago. An armed robbery suspect was shot Wednesday night trying to rob a man and a woman in their own driveway. According to the Selma police chief, his name is Spencer Collier, the incident happened around 11:30 at night in the 1500 block of Leroy Street, if you know where that is in Selma. The couple was returning home and they pulled in the driveway. They were approached by what they later discovered was a 20-year-old male robber. The suspect walked up to the driver's side of the vehicle and attempted to rob the male victim. He wasn't buying it. He, told the guy no, whatever. So the guy went around to the other side of the car, the passenger side where the guy's wife was sitting. According to the police chief there, the robber was able to retrieve a purse from the female victim. The male victim was able then to get his firearm out, and they engaged in gunfire in an effort to both protect his wife and his life, and he killed the robber. You have to picture this, that the robber is standing outside the window on his wife's side of the car, grabbing her purse. The gunfight takes place actually across the inside of the vehicle. The Chief Collier said the would-be robber, was from a local from Selma. He was pronounced dead at the scene. According to Dallas County coroner, his name is Alan Daly, the robber had multiple gunshot wounds. The male victim, who was also hit, was treated for his injuries and released. He's going to be okay. The robber, according to the chief of police, the robber was killed in what appears to be an act of self-defense. He was a convicted felon, and the chief pointed out in his interview that felons by law are not allowed to have firearms. So there's another crime right there. The police chief added that he had consulted with the Dallas County District Attorney. His name is Michael Jackson. I would only put his name in there because Michael Jackson says that this is a good case of self-defense.
Yes.
Although the case will be given to the grand jury for review, of course. The information available here clearly indicates the robbery. It was a robbery, and the male victim returning fire likely saved his life and his wife's life. I wanted to point out from this, it's really getting to be a common robbery where robbers will stake out a house that you're not home. They go knock on the door, prelude to a burglary usually, but sometimes they wait outside for you to return, and then they either carjack you or follow you into the house. When you turn the alarm off, they push their way in and they have your house. The following event is getting fairly common because you walk in the door and you shut off the alarm sometimes before you close the door behind you. Or it's a prelude to a carjacking. They take your car keys and your cell phone and drive away, and you can't get in your own house, so it takes a while to get the police there. Be aware of your surroundings. When you come home late at night, especially if your house is a little bit isolated from the neighbors so you can't be seen, take a look around before you get out of your car so you don't find yourself, as you step out of the car, losing your car keys and your phone and being forced into your house to turn the alarm off. Unfortunately, it's really common. It's just awareness here of paying attention to your surroundings.
Bob, again, of the hundreds of cases you pick out a week, you seem to pick out ones which have old principles but have very timely, relevant points for your viewers and your listening audience.
Well,
This case illustrates 2 points, again, taught in every CCW class, probably in the United States: the castle doctrine and defense of property. Now, in this case, the vehicle, apparently in South Carolina, or was this Alabama or South Carolina? Was this Selma?
Alabama.
Okay. In Nevada,
Yes.
The vehicle is an extension of your castle, providing that you're otherwise legal to be in that area. I mean, if you're in a super secret area of an Air Force base somewhere in Nevada, you're definitely not going to be protected. But in any event, the illustration here points out very clearly that people are still in the car, close to their home, even if they weren't. And notice what the chief of police Collier said, that the husband or the male was exchanged gunfire in order to protect himself and the female's life, not property.
Correct.
Let them have the purse, because in Nevada, unless it's something which is an immediate threat of great bodily harm or death to you, the defense of property otherwise is not going to be justifiable homicide in every case. So I think that what the chief of police pointed out here about the, I guess the husband or the man saying, I was in fear for my life and that of my female companion. We exchanged gunfire. And this is a really good example where, and I don't want any of your, would like to have none of your listeners say, well, I can defend my wife's purse when somebody defend her right to keep that purse. The answer is no.
The answer is yes, you can, but it'll be a big mistake.
Yes, it would be a big mistake. Yes.
There, even and I got to point out, and I don't want to prolong on this first case, but even in states where you have the castle doctrine that say, you know, they're coming to your house, and there's a castle doctrine that says you can shoot to defend your home and so forth and so on, you can still be sued. Even though the castle doctrine says you can't, the suing attorney simply says to the court, the castle doctrine doesn't apply in this case because this is the little wrinkle. And some of those wrinkles might be the age of the person who broke in, or the fact that he wasn't armed, or the fact that he tried to run away and you shot him anyway because he was still in your house. Those cases end up going to trial anyway. The attorney simply sues the law instead of, now it only happens in really egregious cases, but you can certainly get your castle doctrine taken away because it doesn't apply to that particular case. It doesn't happen often, but it doesn't mean you can shoot anybody at any time that violates your perimeter. This case is just drives me crazy. This is from the Sun Sentinel, Local News 15, which is NBC, on the 4th of this month, 4 days ago in Davie, Florida. An argument in a restaurant escalated into a physical fight in the parking lot just after 1 in the afternoon. Two men who apparently did not know each other began arguing inside a restaurant. The subject of the argument, or what started it, was not reported. Anyway, a 49-year-old road construction worker, later described in other reports as a large person, and his co-worker arrived at a restaurant called Polo Tropical on South University Street for lunch. They did not sit together. The co-worker sat near the window to keep an eye on their tools and their truck. Apparently there have been problems with people grabbing stuff out of work trucks and running off. So they're sitting separately. The worker and a 33-year-old customer then got into an argument over something. The worker and his co-worker then both got up and left the restaurant and sat in the back of their truck in the parking lot. The customer remained inside the restaurant for a while and then walked outside toward his vehicle. When the worker in the truck saw the customer in the parking lot, he got out of his work truck and confronted the guy. they got at that point into a physical fight, knocked down and basically rolling around on the ground. During the fight, the customer pulled a handgun and fired several rounds. So we got the customer from the restaurant. He was a legal concealed weapon holder. After the fight, he was apparently losing. He fired at the guy. The worker was struck once. He was shot. After he was shot, he managed to get back into the truck, and his co-worker drove him to a nearby Chevron gas station. There, the co-worker requested help. Authorities arrived, took the wounded worker to Broward Health Medical Center in Fort Lauderdale, where he died. The customer remained at the restaurant and called 911. He surrendered to the police and was detained for questioning. Of course, there's a dead guy. Are they going to detain him? Sure. Yes. Police said the customer fired a handgun, which he was licensed to carry. The worker that he shot, however, was not armed. Davie Police Captain Dale Engel said in a statement Sunday morning, this is 2 days later, based on our investigation, we believe the customer acted in self-defense under Florida's Stand Your Ground statute. That being said, the investigation is continuing. Now, the worker was clearly the aggressor in this case. They don't know what the original fight was about, but when the customer came out to get into his car, the worker got out, confronted him, and the fight started. He's reported physically larger, and he had a friend with him, so there's actually two. The customer that was attacked is permitted to stay where he has a legal right to be. And a valid point here, I think, that needs to be made out. He stayed at the scene, called 911. When the police arrived, he surrendered his gun. He allowed them to handcuff him, go through the whole routine, proned him out. Then he explained what happened. By that point, they had found the other guy who called 911 to get medical help, but lied about how he got the gunshot wound. He said he accidentally shot himself initially. He who stays at the scene to explain generally gets first crack at the investigators believing him. If you're involved in a shooting, don't run away. It makes everybody look guilty. And it starts the investigators off in the wrong frame of mind. Obviously, they're going to get to the right frame of mind when they talk to everybody, but you make yourself look like the guilty party when you run. It's human nature to run 20 feet so you're safe, and then call 911 and stay put and tell them where you are and what happened. Yes. He who calls the police first has the advantage at the beginning of the investigation. Good shoot? Probably yes. Florida does have a stand your ground law that is quite effective, and in this case, where he was clearly not the original aggressor, I think he's on good legal ground, and I think the guy's okay.
I think he'll be all right. One thing is that the Florida listeners or your viewers may want to review something. Before the Florida legislature right now is an amendment, a statutory amendment to the Florida Stand Your Ground statute. So they might want to, your Florida listeners might want to check on that to see if there's been any movement concerning the amendments to that statute, and it would restrict the availability of stand your ground in certain circumstances. But just very briefly, this is a good example of stand your ground is not necessarily when you're at one point. Stand your ground is also a fluid situation where you're moving from the restaurant to the area of the vehicles, back to the vehicles in the parking lot. It's not just one particular location where you have the right to be. And this is a good example of, I believe, the police correctly assessing this as a stand your ground, although it's subject to further investigation. I think in California, I think the customer who pulled the weapon and fired, I think he would be in jail right now.
Yeah, that's a very valid point. I talked at the beginning of the show about stand your ground, but this, we have a case from a relatively good area if you're wanting to stand your ground in Florida. If this took place in San Francisco, look out. It's different. A word I want to drop for Jerry Creed. He's another attorney that I work with. He doesn't come on the show. He doesn't do criminal defense. What he does is elder law and firearms trusts and Class 3 firearms trusts. If you have a trust for passing your particularly Class 3 items down to your heirs, that law is very much in flux at the moment. Jerry keeps up with that, particularly if you have Class 3 firearms. We're looking at silencers maybe being made no longer on the Class 3 list by Congress, etc. You got to be using an attorney who keeps up. And there are guys in town that do firearms trusts that shouldn't be doing them because they haven't looked up a case in a year. Like most attorneys, Jerry Creed, C-R-E-E-D, has free consultations out in Summerlin with the helpful number of 702-806-7777. I know an attorney who uses 7777 on his email.
I wonder who that is.
I often talk on shows about third-party defenses, that they're a crapshoot. You see two people fighting, you can't tell which one is the undercover cop and which one's, who's dressed up like a biker or a criminal, and the guy in the three-piece suit might be a drug dealer he's trying to arrest. You can't tell who started the fight. In fights, sometimes you can't tell when a woman and a man are in a fight. Sometimes the woman is in the aggressor and the guy is trying to defend himself. This is a case, and I always say, sometimes there are cases where it is clearly evident who the bad guy is. And you don't need to bother with warnings and explanations and see if he really draws a gun. This case is just horrible, and fortunately it was saved by a guy with a gun. ABC TV, Tulsa, Oklahoma, reported on the 4th of this month, which is 4 days ago, in Ada, Oklahoma. Authorities say a man who was trying to drown his infant 3-month-old twin son and daughter in southeastern Oklahoma was fatally shot by a neighbor. The city of Ada spokesperson, her name is Lisa Braxter, told reporters that the 27-year-old father died after being shot Friday after a 12-year-old boy ran from the home to a neighbor for help. The neighbor told police he went to the home armed with a handgun and shot the father twice after seeing him holding the infants underwater in a bathtub while threatening the children's mother with a knife. Police spokesman said the children were taken to a hospital in stable condition, and the neighbor was questioned and released by police, of course. An absolutely unspeakable crime was averted here. I put in my notes here that I often talk about the danger of misreading third-party defenses. It can happen when someone is murdering children. Obviously, you know who the bad guy is. In this case, had the homeowner called 911 and waited to see what happened, the infants would be dead and probably their mother. This guy was murdering his own children. This hero made the choice to intervene rather than call 911, and that was clearly the correct thing for him to do. Sometimes it is so obvious who's the bad guy that you just need to jump in because there is no time to wait for the police. In this case, that was right. My hat's off to this guy. Those children will be obviously forever in his debt for moving instead of waiting for the police. When the 12-year-old came over and started screaming that, my baby brother and sister are being killed, the guy just grabbed his gun and went. And yes. Perfectly correct, perfect answer. Another huge example of somebody having a gun saved lives by acting. Good for him.
Suppose, for example, though, In this case, it's in Nevada where we have a statute about protecting your family, protecting your relatives and your loved ones. And you mentioned the point about defense of others in the third party. Suppose that there was the woman was being drowned in the bathtub and not children. Would we have now a murder or a second-degree murder instead of a justifiable shooting? Will this be treated as justifiable homicide?
This case, obviously, if it's taken before a jury, the jury is going to throw the prosecutor right out the room and tar and feather him.
Yes, I agree.
Could you, if the woman is being threatened and you run over there to keep her from being killed? Yes, I would think so. In this case, he had some knowledge of the next door neighbors and who was there. The problem is always, and I know my colleague here will verify this, juries can be a terrible crapshoot, and third-party defenses are one of the things that is a danger. Children being hurt, a woman on the ground being stabbed through the face. That's obviously, the guy stabbing her is not a police officer trying to arrest her. Right. You know, when you see knives come out, that is third-party defenses can be a problem. Make sure that you know what's going on.
Yes.
When you intervene, you're on your own. But in this case, it was great, and a lot of those happen. We just had this thing in London where the guys jumped out of the van and were stabbing people. When the London police arrived, they opened up on the terrorists. They killed all three of them that were stabbing people 8 minutes after the whole incident started. There's a time frame to look at, Sheriff Lombardo. Not only did they get there quick, but they took action. They apparently wounded an American citizen in the background. He's okay, and I'm sure he's happy to take the wound and have those three terrorists killed. Sometimes you just have to act, and then that's why we have defense lawyers. So if something goes wrong, there you are. This is a story out of Atlanta Journal-Constitution on the 2nd of this month. Marietta, Georgia. Just before 3 in the morning, officers responded to 707 Franklin Road, Building 9, big housing complex, according to Marietta Police spokesman Charles McPhillamy. The woman who called 911 said he shot a man who tried to force his way into her apartment. A male and 2 adult females were asked to leave the gathering. There was a big party there about an hour before the shooting occurred. The group left, but the male returned an hour later without the 2 women. He was enraged and demanded to be let back inside the apartment. He began then kicking the door and making verbal threats to everyone inside. When the woman opened the door, maybe not a good idea, when the woman opened the door, the male abruptly reached to his waistband as though he was drawing a firearm. At that point, an adult female inside the residence drew her own firearm. I'm presuming it's the woman that opened the door, but the police report wasn't clear. Right. This might have been a different one. Drew her firearm and shot the male multiple times. The would-be intruder was taken to Wellstar Kennestone Hospital, where he was pronounced dead. The man's identity has not been released pending notification of next of kin. The Marietta police detective said that after reviewing the facts and witness statements with the Cobb County District Attorney's Office, the incident appears to be an act of self-defense. No charges will be filed at this time. Obviously, when someone is beating on your door at 3 o'clock in the morning, it's a reasonably good idea to have a gun with you when you go to the door. I'm not sure opening it was a good idea. Nonetheless, she did. The guy outside was screaming threats, even making it a worse idea to open the door. Your door jam's going to get damaged. But anyway, once again, we have a fool here making a motion as if he has a firearm at an opponent who actually does have a firearm. The result is always the same. Starting a gunfight without a gun shows really poor judgment. I put in my notes, his elimination from the gene pool will not be a big loss for the human species. I don't think. Someone beating on your door at night at 3 a.m, demanding to be let in when the party's over, apparently,
Right.
and everything's calmed down. Obviously, the guy has got something wrong with him. He's enraged about being asked to leave before. You can not open the door. Calling the police a better idea. Maybe she's concerned about getting the damage to the door frame and so forth, and is worried about that. It's an apartment, so she may be liable for the damages. Who knows? One interesting sidelight to this story, Marietta, Georgia, is the original home of Military Armament Corporation, for those of you as old as me, the main manufacturer of Gordon Ingram's MAC-10 and MAC-11 submachine guns toward the end of the Vietnam War. Nice city then. It's got a crime rate problem now, but I just threw that in to show that I'm old and remember this kind of stuff.
Not old, it was informed. Bob, as to this example, where was the perpetrator when he was shot?
In the doorway.
Presumably in the doorway,
Yeah.
outside. In California, the homeowner's probably going to face charges. In Nevada, it's 50-50 maybe, especially if she knew the guy. Now, apparently she may have known him from this earlier get together.
Right.
So, or she may have known that there is a defense in Nevada that if you have knowledge of the perpetrator's propensity for violence, and he apparently is going to assault you, he's going to batter you, you have the right to defend yourself. But how many times in 40+ years of teaching firearms classes and being involved in this every day, have you advised your students and your audience that just because somebody's reaching in under the waistband doesn't mean they're going to pull a firearm? Is that sufficient for great bodily the threat of great bodily injury or death?
Probably not in this case. The guy is shouting threats.
Yes.
And at injuring other people in the house, apparently. We don't have a recording of the threats. She doesn't have a recording of the threats. Were still a number of witnesses there who said he made threats that he was going to harm people inside the house, which the witnesses are there. That's what they're there for. If you're involved in something, take names so the police know who to go interview. Nobody wants to stay around and talk and be there when the police get there because they know they're going to be there all night. There's a dead body. They're going to be wanting statements, this, that, and the other thing. And the witnesses, particularly the uninvolved witnesses, have a tendency to disappear. So try and write down license number or something if it's a good shoot so the police can find those people and talk to them. This is, if you have a similar case and you walk into a bank and you reach into your pocket and say, give me the money, is that an armed robbery? Yes. Trying to convince somebody you have a gun, you are permitted in virtually all cases to believe them. I have them.
Yes, but
But
let's get a young district attorney in the Marietta County, Marietta, Georgia area, where they formerly are the home of Military Armament Corporation. Supposedly he wants to make a name for himself or herself. And they want to use this as an example that it was not a justifiable shooting.
Right.
That's quite possible. And I do see this in California. I can tell you right now that in California, this is probably going to end up as the woman's going to be arrested. Whether or not she'll be found guilty or acquitted by the jury is a separate story.
yeah, this would be an emotional defense. You'd want a jury on this instead of a court trial, my non-lawyer opinion. But boy, if you're going to a gunfight, bad guys, bring a gun. It's a serious mistake to not actually have a gun when you're threatening to shoot people. let me see how time is running here. We're a half hour in. Okay, we're good on this. This is a really difficult case. KVIA, which is ABC TV in Las Cruces, and the Las Cruces Sun-Times, which is located in Las Cruces, New Mexico, just ended a murder trial. The 59-year-old manager of his family's car wash was shot and killed by a 39-year-old customer back on October 21 in 2015. It just went to trial, and this week, on the 5th, the jury came back with their verdict. The customer had once again come to a car wash located at 500 North Valley Drive. What he's there for is to wash the dog feces out of the bed of his pickup truck. He had done this before. He'd been repeatedly told by the manager not to do that. Car washes now recycle their water, and the feces would jam all their stuff. You know, it's picks up grit and sand. It's not ready for dog poop. The evidence shows that the manager made a threatening comment when he filed a complaint against his customer days before the shooting. This was a kind of a regular occurrence, apparently. But defense attorney said the manager shot the customer in self-defense. They claimed the customer was attempting to gouge the manager's eyes out during the initial fight before the shooting and wouldn't stop despite repeated pleas from the manager. District Attorney, the DA, his name is Mark D'Antonio, said the manager was aggressive and witnesses saw him beating up the customer. Defense Attorney Gary Mitchell says the manager acted in self-defense when he took out his gun and shot the customer 3 times. The jury found the defendant not guilty of first-degree murder. Also, they had a lesser included second-degree murder, voluntary manslaughter. He had spent 5 months in jail after his arrest and believed he killed the man in self-defense. That was his claim, of course. He was kind of started out as the aggressor. Now he's losing the fight. And when the eye gouging happened, he pulled his gun and fired. There's cell phone video showing the immediate aftermath of the shooting was presented as evidence, and numerous pictures of the manager's eye injury were shown to the jury. This is a week-long trial that I just redid into 3 paragraphs. There is way more to the relationship. Who was there? Who the witnesses? Is a family car wash. The shooter is the owner, basically. I'm only hitting the high points here. There's lots of details if you want to look up press in Las Cruces, New Mexico, particularly the Sun-Times, has like 30 pages on this. In my view, I hit what I consider the high points here. The actual question was, in this case, is jamming your fingers into somebody's eyes likely to cause serious bodily harm? And at that point is when the guy pulled his gun and fired several shots. Up until then, it was just a dumb fist fight. I think when you try to gouge somebody's eyes out, that is clearly a threat of great bodily harm. And that's why the jury looked at this and said, not guilty. Pretty clear decision to me. This is a really involved case. If you want an education in how shootings go, look this one up. There's a lot of details there.
And I think this is a very telling example for your listening audience and your viewers, because we have what otherwise on the surface is, why did we even go to trial? The guy's eyes are being gouged out. The manager is there.
Are awful.
Right. The manager is there at the car wash, which he manages. Now, there may have been a history between these 2 guys, but the manager is in jail for 5 or 6 months.
Yeah.
It's a week-long trial. There's a murder instruction, second-degree murder, and lesser included instruction on manslaughter, and you point out that the closing arguments took 2 hours. Now, the jury instructions in Nevada will take more than 2 hours to read to the jury.
Yeah.
But your listeners should probably look up this case and say, can this really happen? And the answer is yes. You may sit in jail for 5 or 6 months accused of murder when it appears obvious that you were defending yourself, especially when you can't get any more serious or great bodily harm than someone trying to poke your eyes out in a fight.
It was just a fist fight, and the manager was in reasonable grounds. He apparently started the fight started because he'd called the guy out before for doing this, and he didn't want the dog feces in his grease traps and whatever. I understand all of that, and I understand these two guys both getting their backs up and wanting to have a fist fight over it. The eye gouging, I'm sure that's why the jury took 2 hours after a week and a half trial and just went, that's ridiculous. Because all the defense lawyer had to say, are you in danger of great bodily harm and someone's gouging your eyes out?
Right.
Duh.
Right. And this can happen to anyone at any time, any place, a car wash.
We are forever on this show talking about firearms training. If you keep a firearm, carry a firearm, you've got to learn the rules for gun safety. You got to learn the rules for engaging people. As most regular listeners know, I am no longer working at the gun store. I have retired. However, the classes that they teach there are valid, and it is one of the places that the only place I know of that actually runs the class. They don't put you on a list. They have a class on Monday, Wednesday, and Saturday for renewals. It starts in the morning. For first-time permits, it starts in the morning because the first half is the same. If you're on a renewal, you'll get out at 2:30, 3 o'clock. thegunstorelasvegas.com, or you can call them at 702-454-1110. They're still getting 35 or 40 people for each class simply because they're there.
It's a good class.
You won't end up on a list that says, well, yeah, and I wrote the outline, but that's okay. Don has asked for some time on here to talk about a couple of gun bills. The one one Nevada bill, let me talk about a couple of them first, then I'm going to give Don the handle here. There was a bill in the legislature, Nevada, SB 124, now called SB 124R, it's revised, requires anyone who is subject to an extended protective order or convicted of domestic violence to surrender their firearms and be placed on the list not to purchase firearms. The bill passed the Senate 19-2. It passed out of the Assembly June 1st. It is still sitting on Governor Sandoval's desk as of an hour before this broadcast. He had neither signed it nor said he wasn't going to sign it. It has some civil rights issues there because it takes your guns away without judicial action. If you are given a protective order, which are handed out, of course, by local judges and so forth, then you lose all your guns right then, even if the whole case had nothing to do with firearms. The Nevada Firearms Coalition and most of us are deadly opposed to this. It sounds like we're for domestic violence. We're obviously not. We're for keeping your guns until a judge says you can't have the guns. That's what we do here in America. The other two major bills, AB 118 passed. It allows people who are 18 that are military or military honorably discharged to get a concealed carry permit in Nevada. Passed and signed by the governor. AB 253, an Assembly Committee on Judiciary's bill, no actual author of the committee, Authorizes a central repository of records for Nevada criminals history to show mental health adjudications with local law enforcement for purposes identifying people prohibited from firearms. That has the word adjudication in it. If the court has said you are nuts, they will put you on the list of you can't have firearms. It does allow people to become unnuts later on. If a psychiatrist then certifies you're cured or you're no longer a threat to yourself or others, then you can get your guns back. It passed the Assembly and Senate unanimously and was signed by the governor just a day or two ago, just signed by the governor. Because it requires court intervention,
Yes.
it's okay. We need to be able to keep truly crazy people from having firearms. So that's a no-brainer. Everything else died. There were 2 bills for constitutional carry, died from a couple of conservative senators. The bill that allows a person who holds medical marijuana and still get a CCW died simply because marijuana is still a Category 1 drug according to the feds. So as far as the feds are concerned, you're a habitual user of a Schedule 1 drug. If Congress ever changes that, that may change this. But right now, if you get a marijuana card or you admit to smoking marijuana, you don't get to have guns in the state of Nevada. And that's going to be interesting with some states that issue permits to people who use marijuana. Anyway, everything else failed. Most of the stuff the Democrats tried to put through killed. Now I'm going to turn this over. We've still got this 124R, which is really worrying. Because you just get a protective order against you. In most cases, well, in a lot of cases, the individual that's subject to the order doesn't even know it exists. They just show up at your house and go, stay away from Mary Beth, and now give me all your guns.
Yes.
So that hopefully the governor will not sign that. Obviously, people who are beating their wives and so forth, they're in jail for that. Or another story. Okay, Don.
Well, thank you. While we're still on the subject of the legislative, what's going on with the Nevada legislature, again, our legislature only meets in odd-numbered years, so it's every 2 years for like 120 plus or minus days. But as to Senate Bill 124R, in Nevada, in Washoe County and Clark County, there are 2 ways in which someone can get an order for protection. In justice court, you can go down, you fill out an affidavit, and it's called a request for an order for protection issued through the justice courts.
Right.
On the other hand, you can go down to family court and ask for a temporary protective order against domestic violence. It's issued through the temporary protective order office at justice court, at family court.
Right.
In both instances, it's technically possible for such an order to be issued without you having knowledge, although it's more rare for justice court to issue such an order, but it happens quite frequently with the temporary protective orders issued through family court. As one of my clients found out about a week and a half ago, that her companion had gone to court, filled out the application like on May 24th. On June 1st, which I think was a Thursday or a Friday, the temporary protective order was issued for a period of 30 days. This past Monday, there was a knock on the door by what appeared to be a uniformed officer or marshal, handing my client what appeared to be a temporary protective order, good for 30 days, and she didn't know anything about any hearing, and in none of the papers which were presented to me was there anything on a hearing? So I think that perhaps the governor, being a former attorney general of the state of Nevada, a former federal judge appointed for life and good behavior, and he gave up his judgeship to become the governor of Nevada and run for governor. So I think that he may be seeing some problems. But there's a comparison between Nevada Senate Bill 124R and the bill which died, and that's Senate Bill 387. That was labeled as the certain orders for protection. That was the one which would have allowed ex parte, without any hearing, for someone to say, my husband, my father, my brother is going to hurt himself or others, and it can go back 6 months, or if it's a pattern of conduct, it can go back 1 year. But thanks to the Firearms Policy Coalition, thanks to perhaps your listeners, when we did a show about a month ago, and you gave some time so that we could ask people to consider this, not telling them how to vote, or because you can't vote, you just contact your representatives. But although Senate Bill 387 did pass the Senate on a 12-9 vote, mostly along party lines, Democrats and Republicans, it did not come out of assembly, and therefore, by not coming out of assembly, is not going to be the law of the state of Nevada, as you have in California. Right. I do believe that there are entities, I'm not going to mention any names, which spent a lot of money on lobbying or trying to get Senate Bill 387 in place, so that it's just one more way in which these anti-gun rights groups can literally have the police grab firearms from otherwise good people. Again, all it takes is one person, perhaps a soon-to-be ex-wife, and call up the police, and they grab your guns. And by statistics, and I wanted to point this out, I looked up last night that the FBI right now on their firearms denial appeals are now reviewing appeals which were submitted in August of 2015. That's 22 months ago. I've got like 4 applications pending right now. My oldest was filed in April 2016. So I have the unfortunate task of telling my client it could be another 6 to 9 months before his mental adjudication will be possibly resolved favorably. But I just want to point that out for your listeners. And Assembly Bill 118, allowing our active duty servicemen and servicewomen to obtain CCWs, is a good bill. Yeah. And it's also in keeping with the number of other states which have enacted similar legislation. And in fact, last year, somewhere between July and September of 2016, through Attorney General Laxalt's office, one of his chief and senior deputy attorney generals submitted an opinion which talked about this very issue of Nevada, whether or not Nevada should acknowledge the validity of a CCW issued by another state when that person does not meet the age requirements of Nevada. So now it's going to be clear that we will do that when it comes to our military. But there are a lot of other bills which went through, but we'd be here for another 3 or 4 shows. But if I could take just another moment. Yeah. We always talk about battery domestic violence, and at least once a month in some of your cases, the issue of battery domestic violence comes up, and there's a shooting either by the husband and the wife, the boyfriend, the girlfriend, or the brother-in-law, whoever. But there has been some activity recently in the various circuit courts, and we've been watching a case for about 2 years now. The case is United States versus Pauler, Pauler, and that is case number 16-3070. It is a published decision. You can go online and put in Pauler, Pauler, battery domestic violence case, and it was published on May 23rd, 2017. I do not have the official reporter on that, but in this case, Pauler was arrested and charged under a Wichita, Kansas municipal ordinance for battery domestic violence, and he was convicted. Later, Pauler was found to be in possession of a firearm. The United States Attorney for the District of Kansas filed federal charges. Pauler entered into a conditional plea agreement with his lawyers from the, I believe they're the public defenders in Kansas City, absolutely brilliant lawyers. And what they did is they did the plea so that Pauler could argue the issue of whether a conviction under a misdemeanor ordinance was the same as a misdemeanor statute for the purposes of 18 United States Code section 922G subsection 9, which says that whoever shall be convicted of any federal, state, or tribal or local law prohibiting battery domestic violence is a prohibited person, and by the Lautenberg Amendment now 21 years ago, that's a lifetime prohibition.
Right.
And the 10th Circuit, in a unanimous decision, stated that because Pauler was convicted under a Wichita municipal court ordinance applying reasonable and long-standing principles of statutory construction, an ordinance is not listed in the federal law 18 United States Code section 922G and is not in the form 4473 nor in the instructions of the 4473, which says federal, state, or local law, not ordinance. Now, your anti-gun people are going to say they're splitting hairs, and it's the 10th Circuit out of Denver, where Judge Gorsuch, now Supreme Court Justice, came out of. But it's a very reasoned and well thought out decision, and it's not based on Second Amendment, although it's referenced. It is based on statutory construction, and where you got the Ninth Circuit splitting hairs in the Peralta decision, which is coming up for vote today before the Supreme Court. Today, they're going to vote on whether to grant the petition to review the Peralta decision. Remember, that's a case out of San Diego last year, which held that there is no Second Amendment right to conceal carry in the Ninth Circuit, at least.
Yes.
I don't know. We'll find out tonight, because the justices had originally had their weekly meeting in April, no decision. May, no decision, and now we got Justice Gorsuch on the Supreme Court, and all it takes is 4 of the 9 current United States Supreme Court justices to say we'll hear the case. I think they're going to hear Peralta.
I think they are too.
But anyway, I wanted to point out that the Pauler decision is the very first decision in the United States specifically on the issue of the misdemeanor ordinance not being part of the federal law prohibiting the possession of a firearm, although the ordinance does say it prohibits battery domestic violence. I've got a case in North Las Vegas right now where
we've got 1 minute.
Okay, I apologize. Anyway, they're welcome to call me on this. Thank you very much, Bob.
Yeah, they are splitting hairs, but if that particularly the case that's going to the Supreme Court, you have a right to keep and bear arms. There's nothing in the Constitution about concealed or otherwise. We are, there were some closing notes here. We've got a gun show this weekend at Crossroads of the West at Cashman. I'll be there at least part of the time. My guy that works the table is still off sick. I'll do go over the other gun shows next week. The only one that's coming up right now is this Saturday. And Sunday, I'll be there at least part of it. Got to get over there and set it up tomorrow. We will be back next week from 5 to 6 p.m. Please tell your friends we're on Sunday mornings now. If you want to listen in on your way to church on KSHP 1400 AM. I thank you very much for listening and wish you have a great weekend. There's never enough time to do what I want to do here. We're getting sponsors coming in. Maybe we can get some more radio time when
Thank you again, Bob.
I appreciate it. Now I've been told that all I need to do is push this button right here and we'll be gone. Thanks for listening. Have a great weekend.